Mr. South.
Lords, my lady, I appear on behalf of the appellant, Mr. Dhillon, and friend Mr. Howarth, and his counsel represents Mr. and Mrs. Orchard, together with my friend Mr. Morrell. Court might see, before I begin, perhaps I should check that the court has, I hope, a core bundle of documents that runs to 215 pages, which includes both parties' skeleton arguments. There was a supplemental bundle filed as well.
Yes.
The court should have. And then there is a joint bundle of authorities, which I think runs to 2 lever arch files.
Yes.
I'm grateful. The court may have seen that this is a second appeal allowed by order of Lord Justice Arnold against an order made by Mr. Justice Miles, as he then was before his elevation to this court, which itself was an order made on appeal, that appeal being an appeal from the order of His Honour Judge Duddridge that was made after a 5-day trial in the county court at Southend.
Yes.
The background to the, insofar as relevant, I should say, the background to the claim.
I should say we have read fairly extensively, so I'm not sure you need to explain the background.
I'm very grateful for that indication. Could I just, in terms of background facts, pull out some of what I say are the key findings, A, made by the trial judge, and B, that weren't disturbed on appeal?
Yes.
Insofar as they then underpin the submissions that I go on to make in relation to the substantive point.
Yes.
And certainly in relation to the purported effect of Section 26 of the Financial Services and Markets Act. Perhaps the most convenient place to take the court to draw out those points is the judgment of Mr. Justice Miles. It's, I think, at page 60 in the core bundle, I hope, if I've got the same page numbers as the court. And just to draw these facts out, at paragraph 7, the original agreement being, if I call it the offending agreement, the original sale and rent-back transaction, entered into in 2010 between a company called Red to Black Limited and the respondents to the appeal. Then, as the court will have seen, the property that was subject to that contravening agreement was transferred out of Red to Black Limited to the appellant, pursuant to what the trial judge found was an arrangement that was made in divorce proceedings between the appellant and her former husband. What is noteworthy in my submission in terms of the facts is that there was no finding at the trial, or by the trial judge, that the appellant herself had engaged in any activity that could be or would be a contravention of Section 19 and Section 22 of the Financial Services and Markets Act. It's put by Mr. Justice Miles in his judgment in, if I might say, a slightly ambiguous way, in that he refers to it's paragraph 52 of his judgment, I should say. It's at page 68, paragraph 52.
Yes.
What Mr. Justice Miles then records in the second sentence is that the judge found that even if the claimant had undertaken some regulated activities in relation to the property, she'd not done so by way of business, and he goes on to make further similar comments. That passage, just for clarity, elides the concept of regulated activities and doesn't, with respect to the judge, describe it in the right way. The reason being, I don't know if I need to take you there, but the authorities bundle behind your tab, your tab 22, 21, I apologise, 21 contains the various sections of the Financial Services and Markets Act that are relevant, and page 595, using the page numbers in the bottom right-hand corner, should be section 22
Yes.
of the Financial Services and Markets Act. And it's a basic point which I'm sure the court's aware of, but by way of introduction, for an activity to be a regulated activity, it has to meet the conditions in 22.1. So A, number one, an activity of a specified kind, and B, which is carried on by way of business, and then C, Roman numeral A and Roman numeral B. So where at paragraph 52 of his judgment, Justice Miles said the judge found that the claimant, even if the claimant had undertaken some regulated activity, she'd not done so by way of business. That's not quite right. What the judge had found was that if she carried on an activity by way that was a specified kind of activity, she had not done so by way of business, which meant in turn that she couldn't have carried on a regulated activity for the purposes of section 22 and couldn't therefore have been in breach of section 19. And the obvious implication of that finding is that the activities of the appellant herself, given that they didn't breach section 22, section 19, those activities that she carried on, insofar as she did carry on any activity, couldn't invoke the section 26 provisions. So section 26 doesn't provide any remedy against her because she's not a contributor. That is perhaps a good time to look at the article itself of the secondary legislation, which you should find behind tab 23, page 636.
Yes.
Which is Article 63J of the Regulated Activities Order. The article that makes or renders a sale and rent back agreement a specified kind of activity for the purposes of section 22. And I take the court to this, to make this point. If I can ask the court to turn over the page and look at subsection 6. It's not simply entering into the original agreement that constitutes the specified kind of activity. But by subsection 6, where a person acquires rights or obligations of the agreement provider, i.e. the original contravenor, which includes provider's interest in land, that too constitutes a specified kind of activity.
Sorry, I'm slightly lost. You're at Article 6 on page 637, and where were you going?
Lady, I'm sorry. So perhaps I can wind back and just explain it in this way. So by subsection 1 on page 636, the activity...
Regulated sale and rent back agreement.
Yes, so entering into as what the regulation provides as the agreement provider, so the person that originally enters into it, carries on a specified kind of activity by entering into that agreement.
Mm-hmm.
When then there is a transfer of, clearly this regulation is to do with property, given that it's real property, given it's a sale and rent back agreement, where there is then a transfer of the original contravenors, if I call them that for the moment, the original contravenors' obligations or rights under the original agreement, which includes their interest in the land, then by subsection 6, the person that acquires those rights or obligations or the interest in land also carries on an activity of a specified kind.
And so your point would be this is designed to catch the transferee on by the original person who enters into the
course.
sale and lease back. So
Yes.
you say there's no lacuna that Parliament has not addressed. This is the way it's addressed it. And
Well,
there's
right.
no need for the court to start worrying about transmission to a third party
Correct.
because it's either here or it's not.
My lord's right, yes. And that's why I took the court to the section 22 points at the outset, because I think my lord has the point, but just to make it, once that property is transferred, an activity of a specified kind is carried on by the person that receives the property. The question then becomes, under section 22, do they carry on that activity by way of business?
Yeah.
And it's only when there's a finding that it's carried on by way of business that the section 26 provisions are invoked. And so what you have in this case, and it is a situation where, and it answers the point that my friend makes in my submission, which is, well, what happens if you simply buy the property in Party A's name and then you transfer it straight to Party C? You avoid the automatic sanctions or application of section 26. That in my submission is not right, because in that scenario you go to subsection 6 and you are in a situation where an activity of a specified kind has been carried on.
But Mr. Howe's point still has some force because, of course, if you're not carrying on the activity by way of business, on your case, still there is no remedy.
Correct, because there'd never be a breach of section 22.
No.
But your point is that that is the framework that Parliament has put in place, for
Yes.
good or ill.
Yes.
It's not that it's not turned its mind to the possibility of an on sale, but it has delineated the remedies that are available, and it's, in a sense, it's a, I think you'd say it's a pointer against the court feeling that there's a void that needed to be filled.
That's right, yes. In essence, I say that the scheme that's set out in section 26 and 28, when taken together, provide a complete statutory remedy for the unenforceability created by section 26.2.
I mean, I suppose, and I see that somebody's obviously anticipated this because the relevant bits of FISMA are also in the bundle.
Yes.
There is also the scope where somebody is knowingly concerned in the contravention for a restitution order.
So my lord's absolutely right, and that was the point that I was going to come on to. It was my inclusion in the bundle, and perhaps it's a good time to take the court to it now. Can I, in doing so, deal with this point by reversing back in time to the predecessor legislation, because some of the most helpful indications in the authorities actually relate to the predecessor legislation.
Yeah.
And behind your tab 20 in the authorities bundle, and it starts at page 586. Is the relevant parts, chapter 2 of the Financial Services Act 1986, the predecessor legislation to the Financial Services and Markets Act. And the relevant sections for our purposes are sections 5, which mirror in large parts section 26 and 28 of FISMA. And to my lord's point about the restitution orders, section 6 as well.
Yeah.
And those provisions.
And just to be clear, that's section 6.2, is it?
Yes, that's right, Lord. Yes, 6.2.
But where the Secretary of State recovers any money, or nowadays the FCA recovers any money, it has to go to the people who've lost.
Correct. Yes, that's right. And if one turns back to section 5, these are points that I'll come on to make in relation to section 26 and section 28 generally, but the wording of section 5.1 is almost identical to the wording of section 26. So it provides that where an agreement's made in contravention, it shall be unenforceable against the other party. And that party, so it only contemplates the counterparties to the agreement, my submission. And it includes similar provisions to section 28 Financial Services and Markets Act, subsection 3, which allows the agreement to be enforced, taking into account certain factors, A, B and C. Subsection 4, it contains the same, and if I can call it this, the counter restitution remedy that's contained in the Financial Services and Markets Act. Can I just draw the court's attention? I'm sure it's a point that you've already picked up, but subsection 4, the counter restitution remedy, is also concerned with the agreement, and the phrase "the agreement" is latterly defined in the Financial Services and Markets Act specifically, whereas it's not in the predecessor legislation. And then you have at subsection 5, you have a very similar provision to that which is found in section 28.8 Financial Services and Markets Act, with the reference to the value of the property at the time of transfer. And those provisions were discussed by the court in I take to the first fundamental authority that I have was the decision in Security and Investment Council. And rather than taking the court immediately to the Court of Appeal's decision in that case, can I first deal with the first instance decision of Nicholas Brown Wilkinson, which begins on your page 5 using the bottom right hand page numbers. This was the court might have seen a claim that was brought by the Securities and Investment Board for breach of. It was under the restitution order provision, i.e. similar powers to those that the FCA are given under the Financial Services and Markets Act. But in analysing the effect of the legislation, at first instance, the court, this is on page 7, it's in the bottom right hand. Can I invite the court to read from about halfway down the page, there's a paragraph that starts pausing at this stage and just runs to the end of that paragraph.
Yeah, I'll do that.
Thank you. So the analysis that one sees in the first instance judgment of how Section 5 works, which is the predecessor, as I say, to Section 26, is identical to Mr. Justice Hamblin as he then was reasoning in Brown and Innovator 1, insofar as the interpretation of Section 5 predecessor legislation was such that it was not conferring rights of action against third parties on others, or on innocent parties, the only right of action laid against the contravenor. And there is then discussion, as Malord picked up, there is then discussion of the effect of Section 6 and a comparison between Section 6 and Section 5. And for the court's notice, it's the paragraph that precedes the one that I've just asked you to read, which is Section 6. The Court of Appeal then dealt with, although that wasn't the point that was subject to the appeal, the court made comments in relation to Section 5 and Section 6 of the Act, and it's picked up in Lord Justice Scott's decision, specifically at page 13, in the bottom right-hand numbering.
This is Lord Justice Scott.
It is, m'lady, yes. And counting up from the bottom, 4 paragraphs, there's a paragraph that starts, the present case is concerned with the restitutionary provisions. The paragraph that precedes that, Lord Justice Scott says there are provisions enabling investors to recover loss they've suffered as a result of entering into the share transactions, which the case was then concerned with. There are provisions enabling the contravenor to be stripped of the profit made out of the transactions and for the profit to be distributed amongst the investors. And there are provisions of a restitutionary character designed to restore the respective parties to the share transactions to their former provisions. They're the what are now the FCA's powers largely that the court's talking about. There is then, as you'll see from the present case onwards, discussion of Section 5. And over the page 14, the court says this, and in my submission, when the court says what it says here, it's slightly ambiguous in this sense. So the restitutionary and compensatory provisions of Section 5 do not in terms identify the person or persons against whom the remedy is available. It's difficult to see how the Section 5 restitutionary remedy could be available against anyone other than the party to the transaction in question, or the party to whom, and then I say these are the important words, under the transaction in question, the investor's money or property has been transferred. And I say that the words under the transaction in question are important because what Lord Justice Scott was not then envisaging was a situation where there'd been an agreement made and then property, for instance, had been transferred under another agreement, for instance, a sale agreement, as we have in our case. Hence the use of the word the transaction in question, or the words the transaction in question.
Just thinking around it for a moment and probably getting it all wrong, you've now got Section 27 as well, haven't you?
There is Section 27, yes.
And Section 27 doesn't applies where the property has gone to someone other than the contravenor.
Sorry, Malord, could I ask you to ask the question again?
Section 27 applies where the wrongdoing is really by a third party, isn't it?
So,
let me just...
No. So, well, yes, yes and no is
because
the answer.
It's a situation where the third party has induced something.
Correct, yes.
Wrongly.
Yes, correct.
And there, the property goes to somebody other than that third party.
Yes.
Was there, under the old 1986 Act, an equivalent to that? Probably not.
I think the answer is no, because, well, I say that. Section 5, page 586, is in fact headed agreements made by or through unauthorised persons.
Actually, so that, looking at it, that must be section 5(1)(b)(2).
Correct. Yes.
So there was an equivalent.
There was an yes.
So to that extent, Parliament is envisaging a situation where the property goes to someone other than the actual wrongdoer.
Can I just take a moment just to remind myself of section 27?
Or indeed, you could do it by reference to 5(1)(b)(2).
Absolutely. I wonder if I can give that section some thought.
Yes.
And answer Maud's question.
Yeah, actually, I'm not sure it really helps when you come to what Lord Justice Scott is saying anyway. But
No,
still.
In this sense, although I caveat this by saying I haven't turned my mind to it wholly, the remedy that's provided by section 27 is clearly, it's an obvious point, but it's clearly different to the remedy that's provided by section 26 in the sense that section 26 applies where the agreement's been made by unauthorised persons specifically.
Yes.
And as I understood, or as I understand the point that's made against me, it's that section 26(2) creates a mere equity that can then bind. And so it's really what the effect of section, whether that's right, whether or not section 26(2) does create a mere equity, or whether the scheme as a whole, as I said to Lord Justice Snowden, is whether or not this is a complete statutory code in circumstances where there's an unenforceable.
And I do follow that. I suppose I'm sensitised to section 27 because I think Adams and Options was the section 27 case.
It was.
And of course, you end up with the same process because section 27(2) has the same as section 26(2).
Yes.
And they both lead through to section 28.
Yes, I understand.
So if there's an equity, so to speak, created by section 26(2), then there must be the same equity under section 27(2).
I wouldn't disagree with that. Yes, it's an analysis. I think I was dealing.
Yeah, sorry.
No, not at all.
You got to through the sentence ending in paid or transferred, and you were probably going on to the next sentence.
I think I was. I think I was dealing on page 14, perhaps, of the authorities bundle with Securities and Investment Board, just with the comment under the transaction in question. The investor's money has been transferred. And then the comment whether the compensatory remedy available together with the restitutionary remedy could be obtained by an accomplice who was neither a party to the transaction nor a person to whom property or money or property of the investor has been transferred is equally doubtful. But they don't go on to resolve that question.
No.
But certainly you have the earlier conclusions, if I could put it that highly, of the first instance judge. Section 5 doesn't confer third-party remedies. That then is consistent with Justice Hamlin's latest decision in Brown and Innovator 1. And I recognise that his comments in that decision, which I'll take the court to in a minute, are made over to the decision in Brown and Innovator 1. Behind your tab 5, it's a long decision, as you might out to see. He deals with the section 26, 28 point from using again, it's paragraph 1222. It's page 211, using the bottom right hand page. The first three pages simply set out the statutory scheme and some of the background. There's then at page 214 a reference to the commentary, comments of Lord Justice Scott that I've just taken you to in Security Industries Board and Hansel. And then from 1233 onwards, there is Mr. Justice Hamlin's analysis of why Section 26 doesn't in fact confer rights of action. And without wishing to repeat those points, could I perhaps add to them rather than simply repeat them? In that, behind, could I perhaps ask you to keep that page open in the first authorities bundle and then turn up the legislation itself behind the tab 21 in the other authorities bundle and page 612 specifically, which is section 28.
Yes.
And just to deal with some of the points that are made against me by my own friends specifically. So, by section 28.3, the court clearly has a discretion in circumstances where it considers it is just and equitable to allow either, it's two things, either the agreement to be enforced or, perhaps and, money and property paid or transferred, and then the words under the agreement to be retained. And in exercising that discretion, subsection 4 mandates, hence the use of the word must at the end of the subsection, or the first sentence of the subsection, mandates that the court must have regard circumstances relating to section 26, the issue in subsection 5. And subsection 5 necessarily requires the court, when exercising the subsection 3 discretion, to have regard to whether or not the original contravener knew or reasonably believed that they were not contravening the general prohibition. And so if a third, practically speaking, if a third party, an innocent third party, were to take advantage or to be able to take advantage of subsection 3, the court must have evidence of what the original contravener believed at the time. And my learned friend says, well, that's just one thing that they might take into account and it's a matter of weight. But subsection 3 is mandatory. It must have regard to that fact.
There may be a sort of knock-on point. We're dealing here with land,
Yes.
where, supposing there to be an equity, it would be an overriding interest based on occupation. You don't have to worry about notice.
Yes.
But this legislation doesn't just apply to land.
Correct.
It applies to money, which gives rise to its own problems.
Yes,
But it applies, say, to shares.
it does.
And so where there have been shares transferred to a third party, I think on Mr. Justice Marr's analysis, you would expect the third party to take free of the equity if they didn't have notice.
Yes.
Putting it another way, you would think that in those circumstances you needed to worry about whether the third party had reason to believe that the original party wasn't contravening.
If the argument runs, yes.
But subsection 5 doesn't tell you anything about that.
It doesn't at all.
I mean, you might have thought that if Parliament were thinking about third parties, it would say, well, where the property has gone to a third party.
I agree. Yes. And my lord makes the point that I was going to make in a slightly different context. And it may well be an incorrect analogy, but the point that my lord makes is the right one. The word property doesn't just mean real property in the context of this act. It can mean a whole manner of things. And one of the, for instance, one example, it wasn't, shares is perhaps the best example, but I was going to give you the example of an insurance policy. So if an insurance policy is purchased, for instance, from a person who isn't authorised to enter into or to give out such policies, and that policy is then assigned or transferred to a third party, then if my own friend's argument's right, then the person that's transferred to the third party is entitled to recover the policy or the benefits of the policy. And it's very difficult in that situation to see where that leaves the third party. And it's also difficult to apply the analogy of a purchaser, a good faith purchaser without knowledge to that scenario, or notice rather to that scenario.
How does the expanded reference in Article 63J sub 6 affect this analysis you've just been going through, if at all?
In my submission, it doesn't affect it, my lord, in this sense. So if a party is, can I put it this way? If a party steps into the shoes of the agreement provider by reason of subsection Article 63J subsection 6, so they effectively become the agreement provider, then they themselves, if they carry on that activity by way of business,
Yep.
are contravening the general prohibition.
Yep.
And so are therefore subject to the section 26 remedy. And the question for the court in that scenario under subsection 3, 28.3, would be whether or not that person, i.e. the contravener, reasonably believed that they were carrying on regulated activity. don't know if I've answered my Lord's question, but
Yeah, so you'd read 28.3b. There would be is this right? There would be the jurisdiction in the court if satisfied it was just and equitable the circumstance of the case to allow the money and property paid or transferred under the agreement to be retained, and that would be the agreement would be the on sale.
correct.
And in considering whether to allow that to be enforced or the money or property paid to be retained
Yes.
by the third party, the on sale, you have to have regard to the issue of whether the person carried out the regulatory activity concerned, and you'd say that would be the third party if they did it by way
Yes.
of business. Reasonably, it was not contravening the general prohibition.
Correct.
And you, if I'm right, you say that is the structure of the legislation and the statutory instrument which answers a point which I think comes up in Mr. Howard's skeleton.
That's right. I think it's paragraph 26, perhaps.
Where in fact I thought it was maybe there's another paragraph, but there's a question in paragraph 45.3 of Mr. Howard's skeleton, I think. Where he says it's logically that Ms. Dhillon has the right to ask the court to uphold the original agreement on the grounds it's just and equitable to do so. My question would be to Mr. Howard, but I'll mention it now, is under what jurisdiction? Where does that come from?
Yeah.
Maybe query logical, but under what jurisdiction? You say that isn't right. You say the actual regime that exists is the one that you've just explained under
Correct.
28 as expanded by 63J.
That's right, my Lord, yes.
And otherwise, there is in fact no jurisdiction, and it wouldn't be the uphold the original agreement. It would be the question about whether the third party could retain the property.
Correct.
And
Yeah, that's right, my Lord. And where, with respect to my learned friends, where their analysis goes wrong, is they heighten the effect of Article 63J, subsection 6, to say that when you fall within subsection 6, you are automatically carrying on a regulated activity. What their argument fails to appreciate, in my submission, is that all Article 63J is doing is setting out what actions constitute a specified kind of activity, and those activities have to be broken down and applied in the way that to the rest of the regime, in the way in which Milord's just explained.
Yeah, but you say there's no legislative or regulatory lacuna that requires to be filled by way of mere equities or
No.
anything else. There is just a regulatory regime that applies to whether it's to land or any other
Correct.
form of property.
Yes.
And that's the regime, and you either fit within it or you don't.
Yes.
And whatever you think about the merits or otherwise, that's the regime that Parliament's given us, and if you don't fit within it, you don't fit within it.
That's right. Yeah, absolutely. And that regulatory regime sits alongside all of the other common law remedies, of course, that would be available, or may be available, on the facts of the case.
I mean, without wishing to get too much into the common law, it's sort of quite difficult to imagine what the remedy would be, other than by way of conspiracy.
I agree.
To catch a third party who takes a transfer, even knowing that there might exist a remedy against the original counterparty, unless you've got some form of economic tort.
That's right.
And
Yes.
that's not entirely straightforward.
No, that's right.
And if you could prove all that, you could probably prove knowingly concerned.
Quite.
Then you'd have an easier remedy.
Yes. Well, someone would, yes.
Well, somebody would,
Yes.
yes.
But that's all absolutely correct, yes, in my submission.
Sorry, I took you
No,
out of your way on that.
not at all, Lord. Thank you. There was, it's perhaps a subsidiary point, but a subsidiary point that supports the construction of the legislation that the appellant contends for. My submission arises out of the way in which sections 26 and 28 work more generally, because forgive me for a moment if I just find the relevant reference. At page, it's paragraph 42 of Mr. Justice Miles's judgment. I'll just turn it up. I think you're Thank you. I'm told it's 64. Very grateful. Page 64 in the core bundle. Paragraph 42. Mr. Justice Miles records the argument that was put before him, faithfully in my submission, the second sentence being this. It was said that the judge should have found that the sale and rent back agreement was unenforceable, and that the claimant cannot rely on the purchase by her of the property from R2BL because R2BL did not have title to the property owing to its breach of section 26 and therefore it couldn't pass good title. That in my submission is wrong. The easiest way to explain why it is wrong is by reference to the decision in Whitley Insurance Consultants, which is hopefully behind tab 4 at page 53 of Court's Authorities Bundle. Well, that's the Court's going there. This was a case that...
But sorry,
Lord.
just before you go there,
Yes.
I thought that Mr. Justice Miles had sort of accepted that the consequence of a breach of the prohibition, the general prohibition, was that the agreement was voidable.
Absolutely right. Yeah, absolutely right. He did latterly. Perhaps I don't need to take you to it, but the point that I was going to make.
Okay, and I don't mind you taking this with otherwise, but I just want to know where the end result was, because he did accept that it was voidable, and you can pass property under a voidable agreement.
Yes.
Yeah. Okay.
Yeah.
Sorry,
no, not at all. Thank you. The point I was going to make, you're ahead of me in this sense that that part of the ground of appeal is wrong for the exact reasons that Lord's just given. Perfectly possible to pass the title pursuant to avoidable transaction. If Section 26 did not exist, and we weren't arguing about whether or not Section 26 created a mere equity, the question then might become whether or not the third party's title is defeasible in any way because it's passed under pursuant to a contract that's voidable. That wasn't the point that I was going to make by reference to Whitley Insurance Consultants. The point that I was going to make was that the way in which the legislation works, and this is the points made at paragraphs 23 through to 25 at page 60 of the decision.
Sorry, we're in which?
Sorry, we're in the first bundle of the authorities.
Sorry. Yeah.
Behind your tab 4.
Yeah.
And page 60 on the bottom right-hand corner page numbers. And paragraphs 23, 24, and 25.
Shall we just read those?
Yes, please. And the point that I want to make specifically is this one, that where there's a contravention of section 26, and it may seem like a basic point, but where there's a contravention of section 26, the innocent party is given a right to elect. In much the same way that they could elect where there's been a fundamental breach of contract, for instance. And so the restitutionary provisions in section 28 of FISMA only arise clearly where there's been an election to rescind, for want of a better word, the agreement. That would necessarily require some form of communication of rescission or election. And that would need to be given to the contravening party, because it is that agreement that's being rescinded. And in the instant case, the contravening party, number one, was never told, because it was dissolved by the time that the proceedings were issued of the election. And number two, wasn't a party to proceedings. So the only person that the respondents communicated their election to was the third party. And I say that supports the suggestion or the argument that section 26 is confined to the position as between the counterparties, because it requires communication of that positive election. And I don't say that it's determinative at all. I simply say that it supports the construction that I contend for, that it would require communication of election. And when one then looks at the restitutionary and counter-restitutionary regime that's set up by section 28, it is broadly analogous to a situation where a contract between two parties is rescinded. Because it requires positively, and this is section 28, subsection 7. So, page 612 in the second authorities bundle. Requires counter-restitution to be given upon the election. And it requires it to be, it requires that counter-restitution to be given by reference to the benefit received under the agreement, i.e. the original contravening agreement. So the statutory scheme again only contemplates the position between the original counterparties.
So can we just think about that for a moment?
Of course.
So suppose you have a situation where, I don't know, what should we say, shares.
Yes.
the hypothetical claimant has transferred shares to the wrongdoer for, we'll say, £100,000,
Yes.
and the wrongdoer has transferred to transferee 1 for £110,000,
Yes.
and transferee 1 has transferred them to transferee 2 for £120,000.
Yes.
So what happens? The claimant has to give back £100,000
Correct.
to somebody.
Yes.
You say, well, on the face of it, we're giving it back to the wrongdoer,
Yes.
which doesn't help anybody. But even if we're giving it back to someone else, I don't know, to transferee 2, what's the position of transferee 2 and transferee 1 in relation to the extra 10,000 and the extra 20,000?
So, if Party A transfers shares to Party B in breach of the general prohibition, then supposing Party, if I can say this, or the difficulty with this analogy is that Party B in your scenario is actually receiving a significant benefit because Party B sells on for a profit.
Yes.
Which is practically unlikely to then result in Party B wanting to rescind the original agreement.
No, sorry.
Yeah, unless
I've probably got my facts muddled up. So if I take an Adams adoption type situation.
Yes.
So no, I won't take an Adams adoption type situation. So the claimant starts off with shares, and he is persuaded to transfer them to somebody who is acting in breach of the Act for £100,000.
Yes.
So the shares have passed to the wrongdoer,
Yes.
and the wrongdoer passes them on to transferee 1 for £110,000,
Yes.
and the transferee 1 sells them on for £120,000.
Yes.
Now the claimant says, well, actually, I can see these shares are worth more than £100,000. I'd like them back, please.
Yeah.
So he has to disgorge £100,000.
Party B, the person that received the shares in your scenario, because Party A has transferred the shares to Party B.
No, sorry. The claimant has originally parted with the shares.
Yes.
So he's got in £100,000.
Yes.
So he has to return £100,000 if he wants the shares back.
No.
Am I getting this muddled?
Lord, if Party A had transferred the shares to Party B,
Hang on. Who's Party A? Is Party A the
shareholders?
claimant?
Yes, you described
Yes.
them as the
Yep.
claimant. So Party A is the innocent party
Yes.
in the transaction,
Yes.
and in your scenario has been persuaded, in breach of the general prohibition, to transfer the shares in return for £100,000.
Yes.
And then those shares are moved on.
Yes.
And Party A says, well, the shares have gone up in value, I want my shares back.
Yes.
My response to where that leaves everybody is this. Party A's remedy is to recover nothing, effectively, because he's prevented from doing so by the statutory regime.
I follow that's your case. Yes.
And so what would happen in that scenario is the two subsequent transferees aren't affected.
Yep.
And don't need to prove, for instance, that they had knowledge, and we don't get into the
Yes.
problems.
No, that makes sense in your case.
Yes.
And from the point of view of the claimant, if he wants to, he can claim compensation.
Absolutely. So under the compensatory part of section 26(2)(b), I think, he would have that right, referable by, no doubt, referable by the increase in value of the shares with which he's parted. And so he's made whole, but he's just made whole in a monetary sense, rather than in a proper restitution, in specie restitution sense.
And that won't do him any good if the wrongdoer has become hopelessly insolvent.
No.
But on Mr. Howarth's case, the transferees are going to lose out because
Absolutely.
they can't get any money back from the hopelessly insolvent wrongdoer either.
That's right.
Um,
And no doubt that's why, and one sees this in real terms on occasions, where, for instance, collective investment schemes enter into liquidation, it is those knowingly concerned that are pursued by the authority to return and disgorge profits, and they are then distributed to the investors. And so the mechanism exists. It's just that the legislation doesn't create a private law right of action in that regard. It's vested in the authority instead, in the regulator instead.
And how does it work for land and regulated sell and rent back agreements because of 63J?
If it had been passed on, it would be in a very similar. We'd be in a very similar situation to that which, in my submission, in which Miss Dhillon found herself in. So, if she'd simply been, perhaps I can put it this way: A transfers property to B, that's in breach of the general prohibition because it's a regulated sale and rent back agreement, and then A sells on to party C. Party C is the new purchaser that's just walked into the estate agent and seen the property for sale and has made an offer and bought it. And they've bought the property effectively with a sitting tenant as far as they're concerned, because there's somebody there paying the rent who've got no knowledge of the original transaction. In that scenario, they won't be conducting a regulated activity because, although they've technically carried on an activity of a specified kind by reason of 63J6 point, they haven't done so by way of business, in the sense that they haven't carried on a regulated sale and rent back activity by way of business, and therefore they wouldn't have breached the general prohibition.
And if they were carrying it on in a way that caused them to breach the general prohibition,
then the court would, in that scenario, have to look at the 28.3, just an equitable remedy or discretion.
how?
Because as I think in answer to this question earlier, the agreement would then be the agreement between, because they
B and C in your scenario, I think.
Yes, that's right.
And how does A exercise the election or do whatever A is entitled to do in that regard?
I think it would be B perhaps in that scenario, but B would be able to exercise that election because they'd be exercising that election against the new purchaser.
And that's as a result of 63J.
Correct. Yes.
Yeah.
Yeah, but the sort of scenario we're thinking about, which obviously troubled the judge, was where A, the claimant,
Yes.
enters into a sale and leaseback arrangement with B,
Yes.
in breach of the general, B acting in breach of the general prohibition,
Yes.
but B flips it on
Yes.
to C.
Yes.
Obviously, you've explained what would be the position if C was an innocent abroad and not carrying on a specified activity as by way of business. But if C is carrying it on by way of business, because C is basically the same as B, somebody, but it's flipped on, the remedy that A has is exercisable against who?
Against C.
Right.
I think logically, because the agreement with which, if my lord, it perhaps won't help the answer very much, but the agreement is defined by section 26, subsection 3, which you'll find at page 607.
Yeah.
As agreement means an agreement, the making or performance of which constitutes or is part of the regulated activity in question. And so, if I perhaps call them the innocent party, where the innocent party is then in contract with the third party, not the original contravenor, the agreement, because of the operation of 63J6, the agreement is the agreement that's then in existence between the innocent party and the third party. And so, in my lord's scenario, if the third party had been colluding with the original contravenor and was therefore carrying on the activity by way of business, breach of the general prohibition, then...
Well, they don't need to have been colluded. They just need to have acquired the rights and obligations of the original
That's right.
agreement, i.e. the agreement provider's interest in land by way of assignment or otherwise as part of a business. So there would be a claim that the innocent party could make against C, and the court would then have to operate 28(3), but in relation to the...
That's right.
To the agreement that would then exist between A and the innocent party and C.
Yes.
I think.
Might there be a mismatch? So 28 applies where 26 applies.
Yes.
So going back to 26, you start off with an agreement made by a person in the course of carrying on a regulated activity. Well, that could be C.
Yes.
Is unenforceable against the other party. Well, the other party to that agreement is B.
Yes, that's true.
And then it says...
Well, sorry, can I
Yeah,
just
okay.
for a second? Because if it's a sale and lease back, the agreement by which the lease between A and B is assigned to C.
Yes.
So you do have the agreement then exists between A and C.
Yes.
Except that the property you want back is the property that you sold. And that was transferred to B, so you want to rescind that agreement.
That's right. And this is where the difficulty arises when one gets into third parties outside of section 26 and 28. It becomes ultimately unfathomable, and also potentially for the general property market creates significant difficulties, because we've dealt with, even on Lord's example of the shares transferred to two people, it's complicated enough, but imagine a situation where a property is conveyed to numerous purchasers many times removed.
I mean, where you're dealing with land, Mr. Howarth says, well, there isn't really a problem because any potential purchaser, either the immediate one or anybody down the line, knows there are people in actual occupation because they know there are tenants. They therefore know that those tenants' rights, whatever they might be, will be binding as overriding interests unless they ask them whether they have rights. And if they say they don't have rights, then they won't have overriding interests.
Yes, but that relies on the people in occupation knowing that they have those rights and being able to declare them.
I'm not sure it does. Where's the Land Registration Act? No, I don't know actually. Maybe you're. So, is this paragraph 2 of Schedule 3, page 643?
It's
Perhaps it depends on reasonably. So,
yes.
an interest belonging to a person in actual occupation overrides, except where inquiry is made and the person fails to disclose the right when he could reasonably have been expected to do so.
Yes.
So I suppose there could be room for argument about that.
and it goes, yes. I don't want to make an unfair submission by saying this. It's highly unlikely that 99% of the population know that a sale and rent back agreement is a specified kind of activity to then be able to declare on a subsequent transaction with which they're not specifically interested, other than the fact that they want to perhaps remain in occupation, that they are occupying pursuant to a sale and rent back agreement.
Yeah.
But your broader point is still, however mysterious and difficult it might be to work our way through it, the section 26 to 28 and 60 and Article 63J regime is what it is.
Yes.
And it's not really for the court to graft on or graft onto that regime in relation to land an additional regime which depends upon mere equities and rights of people in occupation.
Yes.
Which of course wouldn't apply in relation to my lord's sale of shares regime. The regime is what it is.
Yes.
For better or for worse.
Yes.
We should operate within it and not graft anything onto it.
Yes. In essence, yes.
But,
There's just one subsidiary point before I finish on this topic, and then perhaps I'll take round three, but only very briefly, subject to any questions the court has. This was a point that made before Mr. Justice Miles, with which he, as of course he was his right, disagreed. But the concept of mere equity, certainly in the context of Section 28 and Section 26 of FISMA, is an unusual concept for this reason. It's clear, and I don't think there's any real difference between my own friend and I, that mere equities generally are inchoate rights. And as such require some other legal steps to be taken before they're exercised, or before they become enforceable. The wording of Section 26 is, on the face of it, automatic. It has automatic application. So, as soon as an agreement is entered into in breach of the general prohibition, the agreement becomes unenforceable by reason of subsection 1.
And even becomes suggests a scintilla of time, whereas actually it is has that status immediately.
Correct, Melody, yes. And so I say this is different to a mere equity for that reason, because the mere equity is inchoate. The effect of Section 26.1 is to create the automatic unenforceability of the agreement. And then the effect is found in subsection 2. And that's very different to a mere equity in my submission. For instance, to give the contrary, or perhaps a contrary example, unwinding a transaction because it is an unconscionable bargain doesn't exist as of right. There's no presumption that simply because the bargain is unconscionable, the agreement's unenforceable, requires the court to take subsequent steps. On the other hand, where, for instance, a mortgage agreement, for instance, is entered into in breach of the general prohibition, and the mortgage is by reason of that breach unenforceable, the innocent party has no obligation to make, other than to give the counter restitution, has no obligation to continue with the agreement. It could simply communicate the fact that it's an agreement entered into in breach of the general prohibition and stop paying the sums that are due, monthly instalments due on the mortgage. And if the mortgage company wanted to enforce that mortgage in circumstances where it's been entered into, it would have to bring a claim, and it would be bringing a claim to persuade the court to exercise the section 28(3) discretion. Which is what differentiates the regime in the submission from the regime or from mere equities more generally.
It's just a different way of saying, read the statute.
It is, my lady, yes. Unless the court has any questions, that's all that I plan to say on grounds 1 and 2.
Well, just following on from the point you've just raised, I mean, it's dealt with by the judge, Justice Miles, at 134 and 135 of his judgment, where he gives two answers to the point you've just been raising, I think. One is, I mean, he says, first, even if not inchoate, the right is subject to defeasance. Your point is, yeah, but he gives it away in the first few words. I mean, it's either inchoate or it isn't inchoate. You can't say,
That's
even
right.
if it's not inchoate.
Yeah.
And then the second is, he says, appears to be a point again, if a merely inchoate right is protected, it would be surprising if a coate one was not. But that's just, you say again, well, that is just missing the point. It's not an answer to the point that a mere equity is generally an inchoate right, not a coate one.
Correct. And can I take, just to make the point, to answer your Lord's point, behind tab 26 in the second authorities bundle, ought to be an entry from Snell's Equity. And subheading Roman numeral, or rather alphabetical letter A, distinction, second paragraph, is where the authors deal with this exact point. And the mere equity is an inchoate right.
I mean, this is the quote the judge set out at paragraph 128.
That's right. But didn't deal with the distinction between coate and inchoate in the context of mere equity. Because if the right's coate, it doesn't require any further steps to be taken, and therefore isn't a mere equity by very definition.
I'm just struggling to find the
No,
actual...
not at all, my lord. It's behind tab 26 or bundle 2.
Yeah.
And bottom right hand page numbers 6, 7, 9.
Oh, okay. Sorry, I've got it now.
And then it's under the heading distinction, it's the second paragraph.
I mean, at the same time, in landlord terms, I'm not sure why it should matter. I mean, if the tenants are an actual occupation, their rights bind a purchaser.
Yes.
If this is a right capable of affecting a third party, well, why shouldn't it bind the purchaser because it's a right of a person in actual occupation?
Because it's not just a right of it's not just the right of a tenant in actual occupation. It's the right of a person that would say they're entitled to be restored as an owner, rather than merely the tenant. Don't know if Lord Justice Snowden has any further questions on that point.
I'm just trying to catch up with my lord actually in relation to the landlord regime. I mean, the concept of somebody in actual occupation having something which binds purchasers depends upon it being an interest, isn't it? I'm trying to process your answer.
You're right, my lord. It's an interest belonging at the time of disposition, so there has to be an existing interest in the property. Point one. Right. Then, this wasn't. This is as I understand the point. So, I may be explaining it incorrectly. I'm sure, but it has to be an interest, and if inquiry is made and there is no, if inquiry is made of a person in actual occupation that has an interest, and they declare that interest, the purchaser is bound by it. If they fail to disclose that interest when inquiry is made, they are not bound by it.
Subject to the reasonableness bit.
Yes, subject to the reasonableness bit. And so the argument depends on whether or not the Section 26 remedy survives as a right, or creates a right, perhaps.
So your ground three.
My ground three, Lord, I'll take it relatively quickly because it's, I think, a brief point. The judge dealt with. I should start by saying this, as the court may well have noted, this was a point that wasn't run at trial. It only arose for the first time on appeal, the mere equity point, and that then necessarily required Mr. Justice Miles to consider whether or not he should allow the new point to be run on appeal, and his conclusion, in putting it shortly, his conclusion was that he ought to allow it because the appellant, then respondents, could be protected by or from, insulated from any adverse costs that had arisen and prejudice that had been suffered by reason of the equity position in the property. He set out the right test. It's at the bottom of page 72 in the core bundle, and it's the reference, paragraph 67, to Singh and Das.
Sorry.
he rejected one of my submissions, which was to the end that if this point succeeded, the trial, number one, might have been run differently, but certainly two would require new evidence. One of the main points in relation to the new evidence or the new findings that any trial judge would, on the Learned Friends case, need to make was whether or not Mr. Dhillon was a bona fide purchaser without notice, which he didn't get into at the trial.
I mean, I think Mr. Justice Miles said that all the evidence was there, but one of the Singh and Das tests, as you just referred us to, is if the point had been run below, it would have resulted in the trial being conducted differently with regards to the evidence at trial.
Yes.
And one of the differences, as I understand it, that the judge accepted would have occurred, which didn't occur, was that there would have had to have been different findings of fact.
Correct.
The judge would have had to have made a number of different findings.
Correct.
It's not just whether the evidence was there, it's a question of what you ask the judge to do with it.
Correct.
And the judge has not made findings of fact on a whole raft of things he'd need to make findings of fact of, as I understand
Correct.
it.
Because even putting aside the bona fide purchase point, we had various other arguments about counter restitution and so on and so forth that the judge just didn't deal with at trial and didn't make findings about.
And the judge, Mr. Justice Miles,
Yes.
in his consequential order, gives a list of things that are to be dealt with at the further hearing.
Yes.
That's page 3 of the supplemental bundle.
That's right.
And is it the case on your argument that all these things would have been gone into at the first trial?
Yes. And the judge would have made findings on those issues had he needed to, depending on where else he got to with his judgment.
And so, I mean, you're criticising, in effect, I think you're saying the judge just got it wrong at paragraph 99, where he says, I'm satisfied wouldn't have required further evidence or have led to the trial following a different course.
That's right.
Had counsel fully explained. And you say, well, it would necessarily have followed a different course because the judge would have made findings of fact, the very findings of fact that the judge accepts at the end of the paragraph, that are going to have to be dealt with at the further hearing.
Correct.
And then are set out in the order.
No. Oh, sorry.
And then
yes,
are set out
yes,
in
sorry,
order.
no, yes,
And the
absolutely.
order, therefore, drives a coach and horses, you would say, through the conclusion at the beginning of 99.
Correct. It's inherently contradictory.
I mean, the other way in which this has been put is in the case called Notting Hill and Shake, which is the follow-on from Singh and Das, which I think refers to, or does refer to an earlier Court of Appeal case, where another way of putting it is, can the appeal court determine the new point of law on the basis of the facts as found by the judge?
Yes.
If that's the test, then Mr. Justice Miles evidently couldn't do it
Correct.
because he wouldn't have had to have a further hearing. Now, I'm not saying that's a black and white test, but it's a fact. It's a way of looking at the question.
Yes, that's right. And then there's the
And then it dovetails into the question of, well, to the extent you're looking to protect the party against whom the point has been raised for the first time on appeal from the adverse consequences of having to have it resolved,
yes,
the expanse of what needs to be done is relevant to the question of the protection.
yes. And and that leads me to this point, which is the way that Mr. Justice Miles proceeded was by saying, well, I'm satisfied that I can adequately protect because there's enough equity in the property to be able to compensate, for want of a better word, the respondent from having to deal with this new point. But that presupposes that all of the subsequent findings that the judge would have to make would lead to the property being transferred back to the original owners, so that they then owned the equity in the property and could use it to compensate the now appellant, then respondent.
When he refers to equity, he means, does he, the difference between value now and purchase price at the time of the original arrangement?
I'm not sure what he meant. I'm not clear on that, because one of the things that had been submitted, or certainly had been considered at the original trial, was whether or not the counter restitution, or it hadn't been considered because there was no finding on it eventually, but one of the matters raised during the course of submissions was whether or not the counter restitutionary provisions in section 28 could be stretched insofar as if the property were returned to the non-contravening parties, they could then be given a period of time to, for instance, try to raise finance against it to return the restitutionary sum if that's what the court required. And so my understanding when Mr. Justice Miles dealing with equity in the property is that he is dealing with the remaining equity after that counter-restitutionary exercise has taken place. But that presupposes success on the part of Mr. and Mrs. Orchard after the trial judge has then reconsidered all of the points that he didn't.
I mean, put a slightly different way. Your point is the protection, the cost protection that an innocent part, the cost protection that a party against whom a new point is taken on appeal needs is not only protection if they win the new point. Sorry, if the person raising the new point wins the new point, which in your scenario you'd say it may result in the property going back.
Yes.
To Mr. and Mrs. Orchard.
Yes.
But it's also if they raise a new point but for another reason fail.
Correct.
Where the property doesn't go back to them.
That's right.
Then how is the person against whom this new point is raised with that consequence to be protected?
Yes.
And there's no consideration of that.
No, and it's a practical impossibility as we understand the position because Mr. and Mrs. Orchard are legally aided at the moment and absent property going back to them have no other identifiable assets that we're aware of. So there was no way in which, or is no way in which.
Whereas the point being that if the point had been run at trial, it could have been dealt with there and then.
Yes.
But it's,
yeah. I think they're one and the same point, looked at differently in some ways. I don't know if my lords and my lady have any other questions of me, but those are my submissions.
Thank you very much, Mr.
Great.
Sell.
Thank you.
Mr. Howard.
My lords, my lady. Can I deal first of all with it isn't quite a scintilla of time, my lady. My lady used that expression.
I
But
don't think I did. I just said it was immediate, that there wasn't any scintilla. Anyway.
the word scintilla rang in my ears and brought me back to landlord tutorials many years ago. But we suggest that what happens here is that the orchards acquire an immediate right to set this agreement aside. And that this right is sufficient to qualify as the type of equitable right that feeds, if I may be permitted the expression, an overriding interest. And we know, because it's common ground, that if they do have an equitable right, they were persons in occupation, they therefore fall within the necessary parts of the landlord legislation, and they have an overriding interest. And we suggest that that is perfectly reasonable. I note plainly my learned friend's reference to Snell on equity, and what the learned editors there say about a mere equity being an inchoate right. My learned friend said that that was generally the case, and I would agree with that. I appreciate that Snell says it is an inchoate right, but equally, there is no authority cited for the proposition that it has to be inchoate. And I made some searches within the authorities to see if there was any express statement that the right had to be inchoate, and found nothing. And we suggest, secondarily on this point, that the categories of rights which can be described as a mere equity are not closed. And we note in that connection that in the Lambert case, which is tab 9 of the authorities, in the judgment of Lord Justice Lewis at paragraph 16, which I think will be on page 275.
Yes.
I'm grateful. I'm having to add 13 to all my page numbers because my bundle isn't quite complete. But he says, I think clear enough that a right to set aside a transaction on the ground of misrepresentation or undue influence is classified in English law as an equity or mere equity, and he gives examples. And then he refers to the Mid-Glamorgan case. Hoffman LJ referred in general terms to a right to have the deed set aside as a mere equity. And then he says, there is no reason to suppose that the right to set aside an unconscionable bargain is any different, although we were not shown any authority directly on the point. And although he does not, I accept, express himself in the terms that I have just submitted to the court, namely that the categories are not closed, I suggest that that is what one can take from the gist of that passage.
With the Mid-Glamorgan case, I can't remember, is that a statutory right? What was the nature of the right in the Mid-Glamorgan case?
I believe it's a statutory right. I'll check that over the shorter German. The Mid-Glamorgan case is the bit that's missing from my authorities.
Oh, I see.
I'm 13 pages out. But I'm pretty sure that it was all to do with compulsory purchase and a right to challenge a decision of the council. So, we suggest, therefore, that the orchards, upon being sold this scheme and upon conveying their property and signing the lease, then had an immediate right to have that arrangement set aside. And we suggest that...
Is the right only to be... Why are the rights not circumscribed by the statutory scheme?
Lord, I suggest that it would be exceedingly unfortunate if they were so circumscribed.
But is that the test? Is the test not that what did Parliament intend when Parliament put in place the statutory scheme under FISMA? Did Parliament, or can we construe the legislation to have envisaged that there would be other legal consequences than that which Parliament has set out in the statutory scheme.
And what I suggest with respect that you can and you should, starting of course.
But which is the test? I mean, the test is not presumably that we think it's unfortunate if there weren't. I mean, that's not a legal test.
No.
We have to try and put it into some sort of analytical framework. The analytical framework is it? Can we discern from the legislation a legislative intent that there should be anything beyond that which is set out in the statute?
Well, that's rather like most submissions trying to prove a negative.
But the trouble is you are trying to bolt on, under the heading equity, in a particular context, indeed of land.
Yes.
You're trying to bolt on an addition to a statutory scheme in one particular type of case.
My Lord, I fully accept that. I make no bones about that.
Yeah.
And my suggestion is, first of all, that one starts, and one can get this from. Name's going over my head. I'm sorry. Adams and Hopkins, and there are various other references in the decided case in that. One starts from the point that the objective, or a primary objective of FSMA is consumer protection.
I was going to say, isn't what we've got to do to look at the statute and the purpose of the statute? And I think that's where you are. And also the provisions of the statute in order to see how that purpose is worked out on the face of the legislation. And then, in this case, to determine whether, taking into account the purpose and the actual provisions, whether there is room for what has been described as your bolt-on, or whether, to look at it in a different way, what does room mean, to look at those provisions and to see whether it was intended that there should be the additional rights that you wish to bolt on.
Yes.
Is that not what we've got? Is that, you're happy with that's what we've got to do?
As a general plan of attack from my side, yes.
Okay.
And my lady, my lords, I would point out, of course, I am not making a generalised plea for equitable relief because it's not fair. I am asking the court to take the concept of an overriding interest binding upon the original party to the agreement and make use of that in order, and here I am, I suppose, pleading specially, but here to do justice.
I have to
recognising that is an interest which should be protected. Of course, that's the whole point of Schedule 3 of the Land Registration Act.
I mean, the set of facts we have here is about the most favourable one could imagine for your argument in a way. Since you're dealing with a specific property, which is somebody's home, and moreover with a transferee of the home who is not as far divorced from the original transaction as another transferee could be imagined to be.
Yes. Yes.
The reason that I was trying to push you a little bit on this, to try and get it into a framework, is that we can, as my lady said, we must start with the statute and the statutory scheme, and we must look and see what the statutory scheme provides in order to understand whether, to an objective bystander looking at this, it would be apparent that that is what Parliament must be taken to have meant. I think the use of the word intended is sometimes criticised because it's sort of, you're not searching for a subjective intent, you're searching for what did the legislation mean.
The intention behind the words used by Parliament, as the court gleans it.
Right. The meaning, I think I'll stick with meaning, but meaning or intent. Okay. And if it's not there explicitly, which I think you accepted isn't, I mean, that's in,
Yes.
then you have to find some technique, nevertheless, to say the legal principles which you contend are to be found to exist, or in my, rather, it was my words, bolted on.
Yes.
Yeah. And what's the process? Is it a process of implication such that it's so obvious that it goes without saying that Parliament would have intended it, or what sort of analytical approach are we applying to the statute? Because at the moment it doesn't seem very obvious that, at least to me at the moment, that Parliament could be taken to have intended the mere equity overriding interest regime to have been an adjunct to the legislation that it was passing. Because you would have thought that if it did mean that, it might have actually given some indication that was the case, or said something about it, to try and resolve some of the questions that we are grappling with.
And I'm not sure, sorry, before you answer that, Mr. Howard, that is what you're saying. I think you're saying, look at what this is all about. It's to do with the protection of the consumer. But then you're saying, in normal circumstances, mere equities arise, and look at the Land Registration Act and overriding interests and do justice. That's what you're saying.
Milady, yes, but if I can throw in a little analytical tweak, I would respectfully submit that one has to take FSMA against the backdrop of the general law, where necessary, and I say it is necessary here. It is true that FSMA is a very long statute which sets out in great detail provisions on more or less everything in financial services, but it is not, in my submission, self-contained, sealed off in a little silo of its own in the law. My lady, I would also, and the Lords, I would also point, if I may, to the rather limited impact that it would have if I were right. There's always a danger, in my submission, of getting too, in any analysis of almost any given case, particularly when it's a statute, getting too narrowly drawn into the application of the words of the statute to the particular facts. And Lord Justice Newey explored with my learned friend earlier on some of the consequences of the application of these sections to, for example, the sale of shares. And in fact, I gave an example in our skeleton argument of that. And there couldn't be any question of an overriding interest in a share certificate.
No, but as I understand Mr. Justice Miles' approach, the equity which, so to speak, arises under the statute could be asserted against a transferee of the shares, unless possibly the transferee of the shares was a bona fide purchaser for value without notice.
My lord, may I have a think about that over the shorter journey? I hadn't understood that to be what he was meaning.
I'm not sure why it wouldn't be so on his understanding of the law. I mean, if for the right to be assertable at all against the appellant here,
yes,
it has to be a right of a proprietary nature in some sense.
yes.
Well, when it's shares rather than land, on ordinary equitable principles, you get to the same result, except you don't have the Land Registration Act telling you about overriding interests. So the transferee takes subject to the equity unless the transferee is a bona fide purchaser of a legal estate without notice. When they get on the register, they presumably get the legal estate. If they bought the shares, then they've given value. But they have to be bona fide. So you get into all the same things, except that you haven't got the Land Registration Act to settle the question.
And my Lord's sort of point follows through. And what Mr. Justice Miles said, I think, in this respect, was probably at paragraph 119, isn't it? And when he's dealing with Mr. Justice Hamlin's decision in Innovator, where Mr. Justice Hamlin himself had touched on the question of bona fide purchase. You see that at the tail end of paragraph 113 of the judgment. And that's the lead-in, I think, to what Mr. Justice Miles says in paragraph 119. He says, I don't consider the problem about bona fide purchase of a value without notice. And then we can read what he says in paragraph 119.
Yes, well, it is right, of course, to notice that he refers in the parentheses to title to land or a shares in action. So he's not confining.
That's right, but
paragraph to land.
But he seems to suggest, I think, that the usual principles of, for example, passing of title to a shares in action might apply. The innocent party is given the usual rights or claims of an owner of property on the footing of the agreement under which the pass is capable of being set aside, and that, I assume, means that he thinks that the bona fide purchaser regime applies. He doesn't sort of say why there's a problem. He just says it is what it is. It's the same principle that would apply in normal situations. So I think, as I understood it, he did think that you would, for example, with shares, have to investigate the question of bona fide purchase.
The innocent party is given the usual rights of an owner on the footing that the agreement under which it is passed is capable of being set aside. And if it's capable of being set aside, that applies to shares as well.
Yeah.
So I have to say, the problems might get even more acute if you look at it the other way round. Suppose it's suppose the agreement involves the innocent party, the claimant, buying shares. So he's now got the shares, he's handed over the money to the wrongdoer. The wrongdoer uses the money to do all sorts of things, and the recipient of the money then does other things. Well, how does it work then? On the basis of section 26, you have a right to recover the money. You can presumably assert that right against a third party. Down the line, how does it work?
And this is upon the assumption within the example that my Lord used, Miller and Friends submissions, that the wrongdoer is hopelessly insolvent.
Well, it becomes more acute if the wrongdoer is hopelessly insolvent. Yes. Insolvency, as ever, sharpens the issues. So the person who originally had the shares, the claimant, thinks, I should never have parted with them. I'd like my money back. We'll suppose that the...
Sorry, I think he would say, my Lord, I would like my shares back.
No. I think what's being suggested is you've got a company that issues shares in breach or is involved in a regulated activity, which I think is buying and selling of securities. I think is a regulated activity. And it, I can't remember whether there's an exemption, but in any event, let's assume that the innocent person buys shares.
Yes.
And hands over the money, gets the shares.
Yes.
The shares crash. And they say, well, okay, I want my money back. These shares were worthless. She never bought them. So they want to hand the shares back to whoever they acquired them from, the company.
Yes.
And get their money back. And in the sort of the very factual scenario we're talking about, the reason that they've crashed is because the company's worthless. So the company, the money's gone, or it's gone to somebody else.
Lord, I think there's a conceptual difficulty within the example there, in that we're talking about money. It's easier if the example is the other way about, because we know what it is we're trying to get back. But if it's money and the funds have been passed to someone else who's passed them to someone else, they would be hopelessly intermingled.
Possibly, or there might be a tracing remedy or some sort of product. I mean, I think the question, these are illustrating the point that I think you say Parliament enacted the legislation into a context, and the context included all aspects of the general law.
Yes.
Whether it, in relation to land, it would be mere equities, no riding interests, and if it was not land, it would be questions of bona fide purchase, property, and for better or for worse, that's the environment into which Parliament enacted it. And unless, you see, I was wondering whether you were going to say, unless there's something inconsistent with the statutory scheme in the general law should operate as a bolt-on where permissible. Or, you know, where possible.
Well, that's the idea I was trying to convey. Maybe I didn't do it very well.
Yeah, but then the question is whether you say, well, hang on, if Parliament has legislated in an area where there's an overlap, for better or for worse, the general law, you know, can't sort of do more than Parliament itself did in that area. And I'm just trying to understand, you see, exactly how you fit your bolt-on conceptually into the statute or alongside the statute in every respect, and I think it's what my Lord is trying to do as well in relation to things that aren't land.
So can I just try the money example? If we have section 26,
right.
The other party is entitled to recover any money paid under the agreement, which is exactly the parallel wording to the other party is entitled to recover any property transferred under the agreement. So here, you've handed over money in return for shares. The shares have crashed. You'd like your money back, please. The wrongdoer is hopelessly insolvent, we suppose. But the wrongdoer has, we can postulate all sorts of things.
Well, let us suppose, my Lord, if I may interrupt
Yes.
respectfully, let us suppose that part of the reason the company crashed is that the company elected to pay a very large bonus to the managing director, and the managing director has that remaining in his bank account. Is the managing director entitled to say, well, it's too bad, it's not his money anymore?
But then ordinary insolvency law principles ought to provide a remedy. Or ordinary company law principles.
Assuming the bonus had been improperly paid.
Yes.
Under company law was, I don't know, preference or something of that sort under insolvency law.
Yeah, let's try another one, which is much beloved of many people in various previous argument. The company was designed to encourage people to invest in a painting.
Right.
Okay, so people buy the shares. Company goes out and buys the painting using the money invested, and the painting believing it to be an old master, and it turns out to be a knockoff copy. It's not worth anything at all. So everybody says, hang on, we want our money back. These shares are worthless. They're only worth as much as that painting hanging on the wall that you used our money to buy. How does it work?
They ought to be able to get their money back from the vendors of the shares.
Well, from the company. The company's paid it to the company has bought.
Oh, I see. Yes.
From somebody else who sold it to
So those funds have gone to the
somebody else.
art dealer who was fortunate enough to
Believe it was
persuade them that it was an old master.
And it turns out to be a knockoff. Nobody was any the wiser until it was tested. But it's hanging on the wall there. There it is. So what happens? I mean, I think you'd have to say, wouldn't you, that if the company had, who would have the additional remedies in those sort of circumstances? I mean, could the person who'd the consumer who'd paid their money, could they in some way attempt to trace in some way? I'm struggling to understand why we go beyond at the moment what Parliament seem to be envisaging, which is in the FISMA environment you operate the statute, which seems at least clear enough for better or for worse. But why do you assume that there's a whole load of additional remedies lying behind this statute?
Lord, I think the answer in the painting example would be to seek to trace the money.
I mean, that's the logic of your case, I think.
Yes.
Can the art dealer assert bona fide purchaser for value without notice in relation to money?
You say he was a bona fide recipient of the money without notice.
Yes, I mean, he has given value for the money in that he's handed over the painting, which was thought to be valuable.
Yeah, which he gave no warrant.
Inquire into the value of that.
Yeah, he gave no warrant. He didn't misrepresent it. He gave no warranty. He genuinely believed it was an authentic painting, but gave no warranty that it was.
So there's no claim under the contract.
There's no claim under the contract. It is buyer beware.
Yes. I think the logic of the case has to be that I would say the dealer can be pursued.
And he, as it happens, has spent some of the money on going on holiday, and some of it is given to his wife under a divorce settlement. So can you go against either Waitrose or the wife?
Lord, I'm not a family lawyer, I'm afraid, but I suspect one couldn't go against the wife. And it would be difficult because one assumes either that it's been paid under an agreement that compromises the ancillary relief proceedings, or it's been paid under a compulsion. In other words, Mr. Justice X or Mrs. Justice Y in the family division has said you will pay your wife this sum of money, which happens to include some of that money. So there would therefore be deep waters in that scenario, certainly.
Can I give you one more example? I mean, just to test all confusing scenarios. This legislation can apply to mortgages.
Yes, it does.
So we suppose now that the innocent claimant granted a charge in favour of the wrongdoer.
Yeah.
And the wrongdoer has exercised the right of sale and sold the property. What happens then?
Assuming, of course, that the mortgage is granted in breach of general prohibition.
Yes,
So,
absolutely.
yes. Well, on the logic of my argument, my lord, I think we have to say you can pursue the house into the hands of
The chargee.
the chargee.
Or the purchaser from the
Sorry, the
chargee.
purchaser from
Yeah.
the chargee.
What happens if the mortgage is not granted in breach of the relevant prohibition? Because that's actually the facts of this case, isn't it? Because as I understand it, the property was charged by the claimant, Mr. Dhillon. There's no finding that it was done in breach of the relevant prohibition. And one of the questions...
The charge to Mr. Singh, I think.
Yes, that's right.
Yes, I'm grateful.
And one of the questions which the judge decided had to be determined on the remittal hearing was, quote, what is the relevance and consequence, if any, of the fact the property was charged by the claimant to a third party? Don't necessarily want to put you on the spot, certainly not before 1 o'clock.
Lord, I'm struggling here because I can't see a clock in the room.
That's right.
No, I can't see a clock either.
This is the
Basic-
second
basic
court I've
license.
sat in with a no clock.
But what's the...
I wish I'd worn my wristwatch.
Well, I am wearing my watch, and it's, according to my watch, it's 18 minutes to 1. But I
Yeah.
must admit, I was very surprised not to find a clock.
But I think the question, Okay. The question is, how do you say that question should be answered?
My lord, there is a complication on the facts. So perhaps I can deal with the actual question, and then I think my lord is right that I will need to consider a more hypothetical version of the same facts, so to speak. Now, the wrinkle on the facts is that it is understood that Mr. Singh is the claimant's father, and in the light of various comments made in the judgment of His Honour Judge Dudridge, which I don't necessarily want to turn up, but I think it suffices to say that the learned judge in the county court had serious concerns over the commercial probity, if I can put it that way, of the claimant, how much she knew about the company's business, and also made various points about her travails in the bankruptcy court, and that's all I want to say about that. So on these particular facts, that's why we were interested to have that short issue determined. But my lord is, with respect, I think, entitled to an answer about what happens if the property has been charged to somebody who knows nothing of the history of the transactions. There's a specific point, of course, in the context of an overriding interest, which is that one would expect inquiries made by such a chargee to reveal the fact that the orchards were residing in the property, and then either himself or by his conveyancer to make various inquiries. So we would say that in this particular case, in the case of an overriding interest, yes, the chargee would be bound, and no, it shouldn't create a problem because the issues had been discovered.
So you just say the normal principles of general law in that, or land law and general law in that respect, apply?
Yes.
I mean, I suppose there is a difficulty, as Mr. Sell was alluding to, that the bit about not disclosing your interest has a reasonableness bit attached to it. So if we have the, I mean, take an ordinary situation. So suppose you have, as here, a sale and rent back, and then the wrongdoer sells the property to somebody entirely innocent, and then somebody entirely innocent, as you would expect, buys with the assistance of a mortgage. Now, both the chargee and the purchaser will be bound unless they can rely on the bit of the Land Registration Act, which is page 643. And that will depend on whether they've identified that the claimants were in occupation, which they certainly ought to have done as they were tenants, and have asked them, which they ought to have done once they'd realised that there were people in actual occupation. But then there might be a question as to whether they ought reasonably have been expected to disclose their rights.
Well, I'm just trying to see whether we can elucidate what the right in subparagraph B means.
I mean, for For the chargee to take free, the chargee has to be able to say, look, I asked, and they failed to disclose the right when they could have been expected to.
Yes, and as I understood my learned friend, he made the point, which is entirely valid as far as it goes, that one would not expect Mr. and Mrs. Orchard, had they been asked, to say, oh, well, yes, we have an overriding interest. But they would have said, well, we live here under a tenancy.
And that would alert the purchaser and the chargee to the fact that there were tenancy rights. But the question is whether the chargee and the purchaser are bound by the Section 26 right.
And isn't the right, or is it, in Schedule 3, paragraph 2b, isn't it the Section 26 right?
Ladies, as I read this, it's the right in relation to the property, not Section 26 right.
Well, on your case, everybody's bound by the Section 26 right.
Yes.
Because of this provision.
Because it's by virtue of this provision that the mere equity arises, which I say makes all the difference in terms of essentially passing the Section 26 right down the line.
So actually, just taking it by stages, the overriding interest is an interest belonging to a person in actual occupation. So here we have tenants in actual occupation.
Yes.
And on your case, a purchaser is bound by the interest, which is the Section 26 right.
Yes.
And then either the purchaser, in this hypothesis, entirely innocent, chargee, entirely innocent, they are bound unless they can rely on B.
Yes.
And for them to rely on B, it has to be the case that the tenants failed to disclose the right when they could have been expected to.
Yes.
And that must be failed to disclose the Section 26 right.
Yeah. To tear up the lease and have the property back.
My Lord, sir, I'm not sure. Well, let me stop equivocating. I don't accept that. In my submission, what the right is here is the right of actual occupation. Whence does it derive? So that, in my submission, what would happen in practical terms is as follows.
Hang on, your clients don't want the lease. They say they want the property back, don't they?
That's right, my lord, but
They don't want the occupation that the lease gives them. They say they want the property back, which they can only get through Section 26.
Lord, yes.
That's why my lord, I think, is putting to you that the right is that has to be protected as an overriding interest is the right that arises under Section 26.
Oh, I follow. Yes, I had been looking at this in terms of what was the right of actual occupation, which is what in my submission A, B, and C are directed to.
I don't think that could be right, because in ordinary land law that would create all sorts of problems. I mean, leave aside our scenario. Regularly, people buy properties which are tenanted. If they know there are tenants there in actual occupation, they know they need to make inquiries of those people to find out what rights they think they have. Now, in that situation, they know that there are people who have rights as tenants. that they've factored those into their purchasing. What they don't want to find is that these people have an option.
Yeah.
Or something entirely different that destroys the value of what they think they're getting. And it's no good if they're not protected against that.
So that the right is, the right there in the option example is a right that doesn't necessarily attach or exist merely because they're
it's not something that comes with an ordinary tenancy, but as it happens, because they are tenants, they are an actual occupation. And so they can assert their option to buy the land for £1, unless B applies.
Yes, so if my Lord's construction is right, then I think it follows from the submission I made about 3 or 4 minutes ago that it would not be a simple matter to find out about the Section 26 right, because I've already agreed with my learned friend, and I maintain that agreement, that if one had asked people like my lay clients, who I'm not sure would have ever heard of the Act itself, do they have such a right under Section 26? The answer would be as I would have to accept.
Just also following on from this sort of analysis, but going back to we're still in the hypothesis that we've been talking about, and picking up the question that the judge thought had to be resolved on remission. Can I just leave you with the question, certainly not immediately requiring an answer, but the judge thought that one of the questions that the trial judge would have to answer is what is the relevance and consequence, if any, of the fact property was charged by the claimant to a third party. Had these arguments been run at trial and that question had been asked, one of the obvious things that would have, I suggest, have to have happened is that the third party, the chargee, would have had to have been joined. Because, for example, the question about whether they had asked, and if so, they would want to address argument on the very points you've just been debating with my Lord about the effect on the chargee of making inquiries and etc., etc.
My Lord, that must be right, because the chargee would be entitled to be heard, because I'm seeking an order which would materially affect his position.
Can you explain to me why that wouldn't have been a materially different course of the proceedings at first instance had the point been run? And I'm just thinking of that paragraph in Singh and Das. It's not just the evidence would have been different, the parties would have been different if this point had been the point that you ran on appeal had been run at first instance. The first thing that would have had to have happened to answer that question would be that you need another person joined to the proceedings.
My Lord, I accept that. My Lord is quite right. That they would have needed to be joined.
Which then, not saying that that's a slam dunk answer to the can you run it on appeal, but it does feed into the question about cost protection.
Yes. Because
it adds a further complications to the actual answer that might be given at the retrial as to whether the property ends up back with your clients or all of it or some of it, or what they get back, perhaps subject to a charge, who knows. It's an extra complication in cost terms, and I just wanted to leave you with that point because I didn't want to spring it on you this afternoon.
Lord, you can spring anything you like, but it's very generous of you to give me advance warning for 2 o'clock.
May I leave you with another question for
Yes,
2
please.
o'clock, which is to go back to where we began, which is about the regime that we've been looking at in Section 26, 28, etc.
Yes.
of the FSMA, and your submission that the legislation has to be seen in the context of general law as a whole, and then it's been described as bolt-ons and other things, and then the discussion about mere equities, and the reference to Lambert and to the Mid-Glamorgan case. And those are actually, there's a little extract from Lambert at paragraph 123 of Mr. Justice Miles's judgment, as he then was, and Mid-Glamorgan is explained at 124. But my question is, in both, are those cases different or the same as this? And therefore, is one just looking at a landscape in which one has the FSMA and all other possible remedies, and can one rely on Lambert and Mid-Glamorgan in that case? Because are they not different, Mid-Glamorgan and Lambert, in the sense that I don't get the impression that there was a statutory regime of the with the amount of detail about who can claim and in what circumstances, for example in Mid-Glamorgan, or for that matter in Lambert, as we've got here. Just leave that with you.
I agree. I think it's Lord Justice Newey's turn.
but my turn is to say, by my watch, we're at 1 o'clock. So, without the benefit of a clock, we'll break now and start again at 2 o'clock.